So, my Lord, before I delve into the three limbs for making a determination on the order sought, the conservatory order sought, allow me underscore three fundamental points of law. The first is that at an interlocutory stage, this court is not called upon to make a final conclusive determination of the questions of law raised in the petition. The second point is that the determination of the application must be tied to the application and to the petition as so framed. It cannot be enhanced to include imagined facts. My Lord, the third point is that the jurisdiction of this Honorable Court under Article 165 is to be exercised on crystallized facts. On the second and the third points that I've raised, my Lord, you note that the petition and the application is premised on a cooperation agreement. That agreement, being contractual in nature, must be read as the text so speaks. And you cannot rely on whatever external facts, extrinsic evidence, and try to make them part of the agreement. The petition and the application is solely on the cooperation agreement. My Lord, the cooperation agreement under clause 6 and 7 is meant to be executory. It is conditioned upon its due implementation is conditioned upon three things. Under clause 6, 1, there must be public participation and approval by the county, Nairobi City County Assembly. Under clause 7, any financial arrangements is clearly stated to be guided by the Constitution and the Public Finance and Management Act, Cap 4:12. Accordingly, and to the extent that the petition is fundamentally premised on 3 points. 1, that there was no county government. As at the time of there was no approval by the county assembly, as at the time of filing this petition, the agreement contemplated that approval, and to that extent, this petition was premature. As at the time of filing the petition, the agreement had not come into full force in terms of its effective date, and public participation was clearly intended in clause 6. As at the time of filing the petition, the execution of this cooperation agreement was intended to flow within the scheme of the Public Finance Management Act. No facts have been demonstrated that there were any contrary budgetary or fiscal law contrary to any provision of the Public Finance Management Act. Accordingly, there can never be a prima facie case premised on facts that are yet to crystallize. I'll take the nugatory and the public interest together. My Lord, you note that the cooperation agreement was both a constitutional and statutory imperative, and a factual imperative, and that is detailed in my written submissions. As a constitutional and statutory imperative, the Constitution under Article 189, 1 and 2 provides the constitutional basis for a cooperation agreement. My Lord, Section 23 of the Intergovernmental Relations Act exemplifies a cooperation agreement between the national and county government. Section 6.5 is specific to Nairobi City County of the Urban Areas and Cities Act. This petition does not challenge the provisions of Section 23 and Section 6.5. And therefore, any litigation meant to curtail the due implementation of a clear provision of a law, which in itself is not under attack in this petition, militates against the presumption of constitutionality of acts of parliament, and further militates against the constitutionality, the presumption of constitutionality or of regularity of government decisions and actions. My Lord, the Court of Appeal speaks in this respect in the Chief Land Registrar and 4 others versus Nathan Tirop Koech. That is captured at paragraph 43 of my written submissions. On the constitutionality, the presumption of constitutionality of acts of parliament, and the caution given by courts never to curtail at an interlocutory stage the due implementation of provisions of acts of parliament, I've quoted the case of your brother, Korir J. as he then was, in Adi and Kamotho at paragraph 42 of my written submissions. Public interest deals in sustaining the due implementation of a provision of a law. Public interest supports the presumption of regularity of government decisions. Otherwise, public administration will be too chaotic if you are first to get approval from courts before we implement public administrative decisions. The presumption is clear: government decisions and acts are presumed valid unless stopped by a court of law. And they should be upon merit determination of those questions. My Lord, on the factual imperative that is captured at paragraph 44, and I want to close with that, and it reads, as a matter of fact, as addressed in the recitals to the cooperation agreement, Nairobi City County, being the capital city of Kenya, has historically functioned not merely as a municipal administrative unit, but as the administrative, diplomatic, commercial, and infrastructure nerve center of Kenya. It hosts government officers, judicial institutions, financial markets, international organizations, diplomatic missions, and regional transport corridors serving the entire country. In addition, unlike other countries whose services are largely resident-based, Nairobi provides daily services to millions of non-residents. The concomitant effect of that is the stretched resources. Hence, the necessity for a cooperation agreement to help sustain the unique position of Nairobi City County government. That cannot be curtailed at interlocutory stage. You risk prejudicing what ought to have been optimized through that cooperation agreement. There's no nugatory. This cooperation agreement will never be rendered nugatory. It is still available to be set aside or to be declared unconstitutional upon merit determination of this. The flow of the funds, the mention of 80 billion shillings, that is not mentioned. in the text of the cooperation agreement. Actually, the text of the cooperation agreement is clear under clause 7 that the fiscal arrangement is to align with the provisions of the Public Finance Management Act. On the fear of revenue collections, be it fees or that is a question of accounting. Upon final merit determination of the petition, if it says this thing ought not to have happened, the fees collected, that's an issue of accounting and really doing the necessary set-off as is appropriate during the budgeting cycle. It has been done before. This is not the first time. That can be cured. I thank you, my Lord.